I would like to give credit to the India Today magazine. I would like not very easy also to interact with such high with people holding such high offices because they are constantly under like not just their movement, people who are meeting them, even their movements and what they do, what they don't do. Everything is quite this thing. It's not that you just to defeat a network. One needs a network to meet him, come back, and just relax and everything. The US itself, the CIA and FBI were not sharing information or actionable intelligence with each other. Statutes, when you read Constitution, there may be certain parts which only a lawyer can understand. And if you go to the Income Tax Act, every case has something new to offer. You have to apply your mind to a fact. Then you have to apply your mind to a fact and then make sure what is the appropriate law that you need to apply those particular facts. Then
So thank you so much, Saga Suri sir, for actually coming up to this podcast, Project 765. It's really an honor to have you here. But before we start this podcast, can you walk us through your journey? Because your journey has been so amazing with a lot of different caps and hats. So if you could hear it from you, how has been your journey from your childhood to till date?
having me, Aditi, and before answering your question, I would just like to plead guilty on the fact that ideally this podcast interview had to happen sometime before, but due to certain things happening at my end, we had to reschedule it. But I'm extremely glad that we are doing it today. Coming to your question as to how has my journey been, I would say if you want to start from the beginning itself, so till class 10th ICSE, I was a below average student and I had no idea that I would be doing law after class 12. But from 11th to class 12th, I did buckle up and I did become a decent or a good student. And so I ended up getting some 90, 91 odd percentage in class 12th. And I would like to give credit to the India Today magazine that in our times, we used to get around when the 12th board results used to come, India Today used to come up with an issue wherein they used to publish list of colleges in all fields. I was just flipping through the pages of that India Today magazine and I zeroed down on ILS Law College, which used to accept students based on the 12 marks. And I also got admitted to Kirodimal College. And once that I think what you intend to ask is that, say, for example, if you are not scoring well, because it was not as if I never used to study for exams or something of that sort. It's just that Indian system of education is such that you are judged on the marks that you secure in the exams, which are almost every time written. So therefore, in that sense, I was a below average student that I didn't used to get good marks or say 95%, 96. I didn't used to get those sort of marks in like when I was in class 9th or 10th. So that's in that context, I've said that. And to everyone who faces that problem, I would definitely say one thing that marks are just one of the many criteria which you need in order to eventually make a good life. And it as you progress in life, as well as in the legal profession, or say any profession for that matter, you figure out that the importance of marks keeps on diminishing with each passing day, or the marks which you got before, the importance of those marks keep diminishing, and you just realize that things which were made out to be so important in the beginning, they do hold some value, but they do not hold the kind of value which apparently everybody made it seem that they hold. So that's one thing. And the second thing which I would tell the kind of people whom you mentioned, students or say young lawyers, is that your concepts of subjects should be clear what you are studying. You should not take shortcuts. You should work hard and you should try and secure good marks because nobody wants to score less marks in an exam. Pressure looks out, and especially when he or she has not consciously chosen that field of study, is that how is your campus? How is the city? So those are the things which initially attract you to them. And say, for example, if there's somebody who doesn't know what law actually would offer or what law studies would actually have to offer him or her, and if you have a very small campus, if you have a city which is not very vibrant, then initially that person or that student would face some difficulty to survive in that ecosystem till the time he or she discovers actually what law study is, what law subjects are taught. Because, see, one thing you should keep in mind in a 5 year law course, wherever you go, even in barring like NLS or NALSA or NUJS, even some of the national law schools in their first year, they don't teach you hardcore law subjects, and it's the same in ILS. So in our college, in first year, we just did not have those hardcore law subjects, whether it was contract law or administrative law or CRPC, ITC, whatever. We just had those normal social studies sort of subjects in our first year, especially in the first semester. To answer your question, Pune as a city did make me feel extremely comfortable because it was a very student-friendly city, and our campus and the college timing and the faculty members there were extremely friendly, and the campus was extremely beautiful. So therefore, in the first semester, most of my friends and myself too, we were quite having good life in the campus and in the city rather than just sitting down and studying. But yes, I can speak for myself. I really thought that now this is definitely something which I want to do for life. Second year onwards, when we were introduced to law subjects, we were introduced to moot court competitions. We were, we were, so in our college, we had a moot court competition where only second year and onward students could take part, and it was on hardcore law subjects with a very complex moot problem, and people from outside would come to judge that particular moot court competition, and I secured like the sixth position in that particular moot court competition in my second year, and besides me, the only person in second year who could make in the top 10 was one other friend of mine who belonged from a different division, and he got some rank 7 or something. So that was when I realized the whole preparation for that moot court competition, sitting in the library and reading books, reading commentaries. Because please remember, what I'm talking is back in 2010. I enrolled in 2009. Second year is 2010. So pretty much still Manu Patra and SEC Online were there, but used to rely on books, libraries, AIR manuals, etc. for referencing and gaining the knowledge of law in particular subjects. And the fact that we had a moot court problem which was similar to a real problem. So you had the facts, you had to read up the law, apply the law to the facts, and then the most important thing, you had to present them to lawyers practicing in real world, and you had to think on your feet. Then there were questions, you had to be spontaneous in answering those questions. So that's the thrill of the profession, and that is something which I really admire even to this day. That every case has something new to offer. You have to apply your mind to a fact. Then you have to apply your mind to a fact, and then make sure what is the appropriate law that you need to apply those particular facts. Then research on judgments, find a perfect judgment which applies to the fact, because you may find 20 judgments. So I see many lawyers saying, oh, that we have like 5 judgments which support our legal proposition. All you need is one good judgment. If it's of a Supreme Court, that's perfect. If it's of a court higher than the court in which you are arguing, that's also perfect. But you just need one judgment, but that judgment has to be perfect. You may have 5 judgments which are either in a way similar or not very much applicable to the case. That would not help it. So that's what really thrills me. And that's second year, to answer your question, second year of college is when I had decided that I would be doing this for life, and I really love this particular field.
Okay, so sir, as you also mentioned, like right now that you were quite interested in law and like the whole law profession in general. So, but your early work also focused on the counter terrorism. So, why did you choose to analyze this particular field? Like, why did you choose counter terrorism?
Counter?
Terrorism.
Yeah, okay. So those were topics, something which used to interest me outside of the law. And being a lawyer, you are trained to not only just read legal stuff, but your mind and your horizon broadens the more you read about things which are beyond law. Say, for example, things which are to do with foreign policy, things which are to do with technology, things which are to do with politics, things which are to do with armed forces, or say something to do with security. So, counterterrorism, the thing which you're talking about, is an article which I had written titled that counterterrorism, to defeat a network, one needs a network. So, what I meant, or what I had written in that particular article, is that how these anti state or terrorist organizations function, they operate in a network, they don't operate in silos. And they have a very sophisticated network, whether it's the financial network or whether it's the network which smuggles arms and ammunitions to wherever they have to operate. So they have a very sophisticated network. And therefore, the conclusion of that article, which I had written, which got appreciation from many prominent people, were the conclusion was that we, as firstly as a country, we don't have that seamless integration between our various police or various enforcement agencies. And at a global level, each country or countries which work together, they also don't have that sort of seamless integration or sharing of information amongst themselves when it comes to defeating the agendas of these terrorist networks. So, what I had proposed in that particular article was that, say, for example, we have a grouping called the Quad. We cooperate on various economic issues in Quad, and now gladly we also cooperate with each other and share information on security front as well. But at that time when I had written the article, it was less, and the sharing of information or a particular actionable intelligence with respect to certain incidents that could have taken place, it was not that seamless or intuitive. And if I would just digress a bit, in the aftermath of 9/11, the tragedy that took place in New York, the World Trade Center thing, the investigations which happened after did reveal that in the US itself, the CIA and FBI were not sharing information or actionable intelligence with each other that seamlessly as they should have been. So in a country like US, something as big happened despite there being actionable intelligence with the agencies, and the only loophole or the only fault being that the integration was not that seamless and the information sharing was not that systematic. So if had the information sharing been integrated and systematic and extremely quick, fast, such incidents can be avoided. And you would notice that since the time the information sharing and the integration between enforcement agencies has gone up subsequently, or has resulted in excellent information sharing or integration. And so that was the conclusion, that every enforcement agency, not just nationally but internationally, they have to be very proactive, hands on, and they need not hold back actionable intelligence or information from other enforcement agencies which may require them. So, yeah.
So, so how did you that article on that collective terrorism and that network led you to an interaction with the principal secretary of to the PM? So, how was that experience overall, and how was everything?
So see, basically, it's something that so I had attended a conference wherein all these the foreign minister, etc., they were in attendance, and that was predominantly a security come foreign policy conference. And after attending that conference, I had written that article, and I'd sent a copy of that article to the principal secretary, which you mentioned, and the foreign minister. And I'm sure that he must have read that article and he would have found that quite interesting, and that too coming from a legal professional. That would have interested him more, because normally you have former diplomats write such articles, but a legal professional writing such article means that uh, that person also has some legal framework in mind which can be developed. So that's how that interaction took place. But I'd almost forgotten about that interaction until you mentioned it right now. Yes.
So, again, talking about your another really good thing, that how did your invitation to the 2018 UP Investor Summit change your perspective on the role of economics, or how did that impacted you to anything in your life? Does that, like, because I personally feel that when you attend and meet a lot of people, it actually broaden your horizon and you are able to think much more widely. So, how was your opinion on that?
Yeah, so I have a strong base in Lucknow, UP. So that's how I keep going back and forth to various parts of Uttar Pradesh, but specifically to Lucknow. And the fact that I attended that summit, see, my since the day I have started my independent practice, one thing I have followed quite religiously is that you need to devote some time to make sure that you attend events or are in the company of people who are not related to law or who are not legal professionals, so as to speak. So I regularly attend events wherein you'd hardly find lawyers or legal professionals in attendance. And that's how I tend to bring a sort of different perspective to that gathering also. And I also take away a lot of things which I may not have if I would have just attended like events wherein law or topics are hardcore legal subjects or so on and so forth. So that investor summit definitely introduces you to people like say large corporations who eventually they need local lawyers for assistance, and they need a person who understands how the legal system in India works. So that's something you have to offer for them, and in return they offer you a perspective that there is a lot of economic activity which is going on outside India. Because please understand or please appreciate the fact that the large corporations which attend or make commitments in these summits, they work in various jurisdictions. They are not, I'm not saying that none of them can be just solely India based, but most of them have a multi jurisdictional presence. So you also, as a lawyer, gain a lot of information or insight as to what all is happening in the other jurisdiction where that particular company operates, because eventually you interact with their legal teams outside India. So it's basically a win-win situation for everyone. And as for investment and everything, I definitely think that government's job is not to get into the business part, or government's job is not to interfere in sectors which should be run by private institutions or private conglomerates or private companies. So therefore, investment like roads and all, constructing roads and all public infrastructure is all right. But I think the time has come now wherein the government should reduce its footprint on as many sectors as possible, and should focus more on governance, facilitating private sector to occupy as much space as possible in the functioning of the nation. So yeah, that's my take on that.
Yeah. So you have been constantly meeting Rajnath Singh sir also. So how is your take on that, and how does that thing influence your law or like anything part of life? Because meeting people who actually is some sort of running the country is absolute an achievement, and they teach you so many things. So how about that experience?
So see, how I had got introduced to him is quite this thing, and I would need to give some context on that. So the thing was, I definitely knew him before, and like I told you, I have a strong base in Lucknow, and he has a lot of. Now he is a member of parliament from Lucknow. But even when he was not, when Atalji was the member of parliament from Lucknow, he used to have a lot of presence in and around Atalji's close people. So my family or I, let me put it that way, we did know him. But even when I had started practice, I had never made an effort or an attempt to meet anybody in the government or any political person, let alone such a person holding such a high constitutional office in the government. So, and to just give you a context, so in 2014, when I joined Mr. Tripachi's office, I had been with him for say 1.5, 2 years, and I don't have any memory of anything besides work. And the only vacation which we as chamber colleagues used to have, they were when Mr. Tripathi was out on vacation or he was not in office. That those were the only time when we used to have our vacation. But even when during vacations, if sir was in his office or in he was working in his chambers. So he used to attend his chambers. So for good 1.5, 2 years, there was no occasion for me to even interact with anybody besides my chamber colleague and think about anything besides the briefs which or the files which we were assigned in Mr. Tripathi's office because he was an extremely hard taskmaster. It was only when I switched from Mr. Tripathi and after some gap, I joined Mr. P.S. Narasimha's chamber, who was the additional Solicitor General at that point in time for the Union government and the Supreme Court, that I thought that now it may be an appropriate time that I may just sort of interact with people who are in the government. And I knew like very selected people, and the Honorable Defense Minister, that time the Honorable Home Minister, was one of them. So my interactions with him initially were extremely personal and just some something here and there. But let me just point that out that I never sought any sort of empanelment or any sort of personal favor from him in terms of my profession or in terms of the fact that if he could help me in my professional upliftment in any man. That was never the case. But it was just that it's always better to meet such people who are in control inside the government, especially if you're working in a chamber or in an office which is predominantly a law officer of the government itself. And slowly and steadily, during my stint in Mr. Narasimha's chamber, when there were certain matters or something of that sort, then during interactions, a very passing reference of such matters used to come. But it was more or less a personal sort of equation, and there was nothing official or nothing official being discussed in those meetings. And and finally, when Mr. Narasimha got elevated, so I had left Mr. Narasimha's chamber and I went independent uh, around the same time when just Mr. Narasimha put in his papers as ASG, and after some time he got elevated as a judge of the Supreme Court. So yeah, that was about my interaction with him. But let me tell you, it's not very easy also to interact with such high with people holding such high offices because they are constantly under like not just their movement, people who are meeting them, even their movements and what they do, what they don't do. Everything is quite this thing. It's not that that you just go meet him, come back, and just relax and everything. So that's the substance of
Yeah. So, like, I 100% agree. It's not possible. Like, it's not easy. I will not say it's not possible, but it's not that easy how much it seems. Now, talking about the journey that you said that did not get any vacations or as short of things, but I can agree on that because I have my parents and they are lawyers, so I can really relate that you don't have any, you know, work life, like after work life you don't have any some sort of like big family life. Even my parents are working when we go to vacations. So, like, the question that comes from this is like the students who are from law colleges or some high schoolers who want to go in law profession, they think that they see good part of the law career. So, if you could tell us some, not bad, but some dark sides or some phases that not a lot of people.
No, no, not dark. I have not come across any dark side. But what you mean is, what are the difficult sides, or
Yeah.
what are the difficult choices which you may have to make in order to be a person with some decent reputation in the litigation? That's what you mean, I presume.
Yeah, yeah.
Yeah. So see, basically, let me be honest with you. One thing which has to be there is that you need to love what you are doing. So I see many people around me, and that say for example, if they're working somewhere, their heart is not exactly in their work. They are just working either to just maintain that sort of a job security, or they are there for money or something of that sort. People who are working in corporate setups, or people who are working at desk jobs, I'm talking about them. Now, one thing which litigation does is that, firstly, my experience till now has been only a person or a student who would really love the litigation aspect of the law would enter that particular litigation only if he loves doing litigation, and he actually loves the field of law, because initially the profession doesn't offer you any money. And when I say doesn't offer you any money, I don't mean a complete zero, but it just offers you money which is sufficient to keep you afloat. So naturally, the people or the students who enter or take up litigation as a choice do it because they love that particular thing, which is you read files, you go to court to make arguments. Sometimes you win, sometimes you lose, sometimes you present a very good argument, sometimes the judge appreciates it. But even that comes quite late in the profession. So if I were to tell you, say for example, for the first 3 or 5 years, you would be working in a chamber, or you would be working for a senior, and that senior is somebody who has to appreciate, who has to guide you through. So you have to be of some value in terms of the profession to your senior. That is when you would graduate, or that is when you would move to the next stage of litigation, which is, say, after 5 to 7 years, when you go independent. So what I mean to tell you is, and especially the chambers which I joined, they were pretty hardworking and very. I'm not saying that we used to work late, like say 1 a.m. or 2 a.m., but we used to work hard and we used to work sincerely. And my seniors used to rely on us, and not just me, even my other chamber colleagues. Like for example, Mr. Tripathi, he used to rely completely on his juniors and the briefing counsel for whatever is contained in the file. Of course, he used to read the file, but he used to also rely on us quite heavily. And when you see that a person of that stature relies on your reading of the file, or whatever you tell him, what points or legal propositions can be argued, then you yourself think that I have to slightly up my game, or I have to work more, and I have to spend some more time, and I have to work more sincerely. So it's basically a very organic process for somebody who really loves this particular uh, field of law, that is litigation, or particular career of litigation. If you don't love it, then somewhere you will falter, and your journey may end abruptly. So I have like many friends who entered into litigation, but they quit this particular thing, say after 4 years, 5 years, because of one reason or the other. And sometimes even money is also a factor, that the gestation period is, for some, it becomes so long that it's difficult for them to survive without that sort of money in the ecosystem which we live. So one has to be hardworking, one has to be sincere, one has to avoid shortcuts, one has to take the harder way, one has to avoid taking an easier way. And the last, and by no means the least, one has to be at the right place at the right time. What I mean by that is destiny also plays its role.
Yeah. So, as so somebody, let's say, who wants to join the law profession, or somebody who is just like first year, second year graduate, how would you like to tell them? How do people actually research a case from scratch? Let's say you have an imaginary case right now. How would you actually examine that from scratch?
A case file just as a novel or a book, as one would read, just to absorb whatever is there in that file. After that, I would read the index of the bare act and mark the sections in that particular statute or act, which I may think that they may be relevant from the headings. You are able to make that out. And then I would read the text of those particular sections, and once I figure that out, that okay, this section, this particular section, or this particular set of sections seem to be quite relevant to the facts which are contained in that particular file, then I would take out the commentaries or the reference books of that particular act and go to that particular section and read the commentaries on that. And finally, I would end my research on looking for some recent case laws, preferably of the Supreme Court or of some prominent High Court or division bench of the High Court, as to what is the recent position or the recent interpretation of those particular sections. And if that interpretation, which is contained in those case laws, help my facts or my client's facts, I would use those case laws to supplement my case when I present them before the court. So that's broadly how the process which I follow.
Okay, sir. So now when we jump out to basically talking about the law profession, if you could take a moment and explain a little like terms that are related to law for the audience to understand better, because sometimes I even don't understand few things. So if you can take a moment and explain a little bit of terms related to law, it would really mean a lot for our next section.
So, see, for example, in law, the language is quite technical. So, initially, when we used to read uh, sections, we used to think that it's different from English that we read in novels. So, say for example, notwithstanding is a word which you would find in almost every act in Constitution. That notwithstanding subsection such and such, if the and then whatever is the text. So that notwithstanding is a term which essentially means that just forget whatever who you have read previously in the other preceding subsections, and whatever is contained after the phrase or after the word notwithstanding would have priority over whatever is contained in the previous subsections. So it would be quite difficult. I can understand it would be quite difficult for a person who's not a lawyer to make sense out of that particular thing. That notwithstanding subsection such and such, if it is, and then whatever it is. So notwithstanding is one thing which is quite, we see that quite often. Then the next is provided. Provided is something easier to understand, but then again you have a lot of law interpretation on whenever it's provided, because when some where it's written that provided such and such things happen, that means it's a it's a contingent provision, that unless such and such things happen, provided these things happen, the part which is mentioned above would not take place. So that's a contingent clause, or that's a contingent section which is dependent on happening or not happening or of a particular event in which that particular provision would kick in. So that's provided, and then there are a lot of terms, notwithstanding, provided, unless something happens. In law, the beauty of law is there are judgments and there are interpretations done by the Supreme Court and downwards, wherein you find that somewhere it's written or, that either this or this, but the courts have said that in such cases, or would be interpreted to mean as and vice versa. So these are some things which are very specific to the field of law, which you would not find in any other profession. Otherwise, English across the board is the same when it comes to other aspects of law, whether it's management, whether it's medicine. It's in English which makes sense to a common person also. But when you read statutes, when you read constitution, there may be certain parts which only a lawyer can understand. And if you go to the Income Tax Act, which is a mother of all complex acts or complicated acts, that even certain lawyers find it difficult to understand what the particular section says, because it has some 20 subsections, 25 subsections. So yeah, it's quite complex, and therefore, as lawyers, we are trained to decipher what the real meaning behind that legal jargon is.
And so, talking about the case that you have overlooked recently about the MAA, MHAD case, so if you could explain that to us, it would again.
Actually, that was not a very recent case, but yes, that was a case which was quite a high stakes matter. That was, with respect, that was a tender matter, and the reason why that was so prominent was that I cannot divulge much information as to who was behind what, but it was basically two political factions, or a businessman, let me put it this way, that businessmen backed by two political factions fighting for a particular tender in Mumbai. So in Mumbai and in the metropolitan area of Greater Mumbai, there was a tender was floated by MAHADA, which is Maharashtra Housing and Development Authority, wherein a tender was floated for giving on lease, or giving certain advertisement sites to concerned players, and whoever would bid highest, that is, whichever company which is into the advertising business would bid highest for those advertising sites, as in the company which would propose that I would give the highest revenue back to the government if you give me rights to put advertisements on these particular advertising sites, that party would win that particular tender. So it was an H1 tender, not an L1 tender. Normally in government contracts, when government has some work which it wants third parties to do, government says that whoever party would quote me the lowest price, that is L1, would be the successful bidder. In this case, it was the aspect of collection of revenue for the government, or the instrumentality of the government. So therefore, the criteria was that whichever bidder promises me or undertakes to give me the highest revenue from those advertising sites, I would give that particular tender to that particular bidder. Now, the technical qualification for that particular matter was that advertising sites are also not that simple how we think them to be. Because before doing this matter, I used to think every site is an advertising site. But then once I did that matter, I could differentiate between a normal hoarding, a gantry, a foot over bridge gantry. So the qualification was that unless you have a full-fledged advertising site, only those would be counted for technical bid. But if you have put in gantries, if you have experience of putting a foot over a gantry on a railway bridge or a foot over bridge, that would not count as having put an advertisement when you file your technical bids. So be that as it may, my client was the successful bidder before the High Court. The party which had not won that particular tender approached the Supreme Court, got a stay in that particular matter, and therefore my client was suffering a lot of financial loss with each passing day or a month, because the tender was for a fixed duration, and the period of whatever was the period of stay, that is essentially lost out revenue for my client as well as the government. So normally these are normal tender matters, but what makes them exceptional is that for one party, that is the petitioner, that is the unsuccessful bidder, it was Mr. Mukul Rohgi who was appearing, who is a legend and by far, I think, one of the best legal counsels which we have around in India today. And the other side was myself, that is the successful bidder, and Mahada was being represented by Dr. Abhishek Singhvi, again, undoubtedly the best. According to me, he is undoubtedly the best senior counsel in the Supreme Court, so, or in any other court for that matter. So that made that matter so interesting and relevant. And I had also briefed senior counsel Gopal Shankar Narayanan for the successful bidder, but to my good fortune, Gopal Shankar Narayan was stuck in some other court when the matter reached, and I got to argue alongside Dr. Singhvi. So that was a privilege in itself, and that's why that matter and that matter got over in our favor, and my client was again declared the successful bidder, and he finally got the tender from the Supreme Court. So yeah, that was the legal issues which were involved in that matter, but more than the legal issues, it was. And normally I tell you one thing, in all these big cases, or in all these cases which are so prominent, the legal propositions are almost the same which you find in any other normal matter. But it is only the stakes and the legal counsels which are appearing in those matters which make them a very high profile matter, a very talked about matter, a very well reported matter. So it's basically a function of who is appearing and what are the stakes. And these two are the best, by far the best. And Dr. Singhvi is, according to me, even slightly better and one notch higher than any other senior counsel which is around. If the client can afford Dr. Singhvi. So yeah, and just on that one thing which I would like to mention, why appearing alongside Dr. Singhvi in that matter was quite a privilege, or something which I really liked, was that Dr. Singhvi, when in 2017, when I was filling my Supreme Court Bar Association form, so we have to take membership of the Supreme Court Bar Association. So he was the person who proposed my name along with Mr. P.P. Rao. Now, unfortunately, he's no more, who was again a constitutional doyen in the field. But these two people did sign on my Supreme Court Bar Association membership form, and that itself holds a lot of value for me. And since then,